Hello everyone, this is Dr.P.Syamala from the Department of MBA, IB, Acharya Nagarjuna University, and our today's topic is regarding Foreign Trade Development and Regulation Act 1992. So, we all know that foreign trade is nothing but a trade between two countries. That is known as a foreign trade, exchange of goods and services or technology, which is exchanged between two different countries or more than one country, is known as a foreign trade. Okay, so trade between two countries, maybe between the two countries or more than countries, multinational. Okay, so that is known as international business also. Okay, for foreign trade. Now in that foreign trade, what does it includes? Exports and imports. Foreign trade means exchange of goods and services along with technology. Okay, and which is done in both ways, means exports and imports. Foreign trade involves both exports and imports. Exports means we are exporting our goods to other country. Okay, goods from our country are transferred to other country, means we are selling our product to other country, goods and services to other country. That is export. Import means we are purchasing other countries goods and services, means goods and services are coming to our country, is known as imports. Well, so foreign trade means exchange of goods and services with technology, and it involves exports and imports. Okay, so now what is the objective? So objective of FTDR, or else the Foreign Trade Development and Regulation Act. So what is the main purpose? Main object is to provide a framework. Okay, to provide a framework for development and regulation of foreign trade. Development and regulation of foreign trade by facilitating. Okay, we aim for development, at the same time regulating also. Okay, so regulations on exports and imports. Okay, how means by facilitating imports into the country, means some liberal laws were there to import. Some facilities were given to the importing of goods, means coming into our country. So some facilities were provided, facilitating imports into the country, as well as taking measures to increase exports. Okay, so at the same time we have to take measures to increase our exports, then only development can be seen. Okay, from India and any other related matters pertaining to foreign trade. So the main objective is development, at the same time regulation. Development is relating to the exports. Okay, and also regulations will be on imports. Why? Because from foreign country we are importing products. So while importing products, there may be some specified class, some specified goods and services which will not be allowed to our country. So in the next classes, ongoing classes, we will learn. Okay, so what are those specified goods and services? Okay, so there is a development and also regulation of foreign trade, similarly facilitating imports and also taking measures to increase our exports. If we see FTTR Act, it was replaced by the Import and Export Control Act. Okay, previously we don't have Foreign Trade Development and Regulation Act. Okay, so until this act was emerged, okay, this Imports and Exports Control Act 1947, okay, we are following in the foreign trade this Import and Export Control Act 1947. Okay, so now this Import and Export Control Act was replaced by this FTDR. So due to some pros and cons in the Import and Export Control Act, okay, so we have amended the laws and this FTDR was replaced in that act. Okay, and this Foreign Trade Development and Regulation Act contains 6 chapters, 20 sections. Okay, how many? 6 chapters and 20 sections. So today the entire scenario of exports and imports in India is regulated and managed by the Foreign Trade Development and Regulation Act 1992. Okay, according to the laws, according to the regulations, according to the notifications in the foreign trade, okay, FTDR. So all the procedure laid down in the FTDR, according to that only exports and imports in India are regulated and at the same time they are managed. Okay, so this act is considered as supreme legislation, right, in accomplishment of the foreign trade taking place in the country. And who will be the authorized person? Okay, who will be the authorized person for the FTDR? Okay, why? Because in application of this FTDR rules, an authority should be there, okay, to frame the policies, okay, to give notifications, okay, to frame, to have restrictions, regulations on the foreign trade. At the same time, they have to give some powers to exercise for to exercise their duty, their to fulfill their responsibility regarding if there are any contraventions in the foreign trade, okay, done by the exporters or importers. So the punishment regarding that, the penalties regarding that, the contraventions, the cancellations of licenses, so or else appealing, okay, so all these aspects will be seen by this Director General of Foreign Trade. Okay, Director General of Foreign Trade, which is known as DGFT, is the agency of the Ministry of Commerce and Industry of the Government of India, responsible for administering laws regarding foreign trade and foreign investments in India. So the Director General, the person will be the authority, the adjudicating authority will be from the Ministry of Commerce and Industry. Okay, ultimately the powers will be vested in the central government, CG. Okay, so according to the CG instructions, the Director General of Foreign Trade will apply his powers and duties. Okay, and if we see what were the features of FTDR, okay, so first one is the it has empowered the central government to make provisions for the development as well as regulation of foreign trade. Okay, so according to the FTDR, who has the provisions to develop the law or else to regulate the law? Means, first of all, the central government has the provisions. Okay, according to the instructions of the central government, only the DGFT, Director General of Foreign Trade, will act. Okay, and this act authorizes the government. Okay, what does this act do? It authorizes the government to formulate, okay, as well as announce the export and import policy. First of all, FTDR gives the right for the central government. It empowers the central government to make provisions on the foreign trade. At the same time, it authorizes the government to formulate as well as announces the export and import policy and also keep amending the same. Okay, not only we are framing the rules and regulations, at the same time, according to the time, okay, according to the situations, amending the policies also will be done by the government only. Okay, And the government has also been given a wide power to prohibit, restrict and regulate the exports, okay, and imports. Okay, not only it liberalizes, okay, not only it encourage the exports and imports. At the same time, if at all the goods and services that are being done in this trade, okay, affects the people of the country, okay, or else it is harmful to the society, the people, the industries, means in such cases the government has a wide power to prohibit, restrict and regulate the exports and imports, okay. That too, in some specified cases, there are some special class of goods and services which are not allowed to in our to our country, okay. At the same time, another feature is the act provides for certain appointments, especially the DG to advise the CG, okay. So another important provision was given, means appointment. So appointment of whom means the Director General, okay. He gives advices to the central government and the central government appoints this Director General, okay. So, and the Director General gives advices to the CG, central government, in formulating imports and export policy and also to implement the same. In formulating and at the same time implementing also, the Director General plays a key role with the permission from central government. The act commands every importer and exporter to obtain a code number. This is very important. Why? Because without the person or the trader who is not having a code number means, okay, that too, this code number is given by the Director General, the authorized person, okay. He only gives the code number to these traders, either he may be importer or exporter, okay. Without having a code number to them, no person is entitled to do exports or imports, okay. So this act provides that code number. According to the rules and regulations in this FTDR only, they can get the code number. These traders can get the code number from the Director General. And the act provides the balancing of all budgetary targets, okay, in terms of imports and exports, so that the nation reaches the very peak of economic development, okay. Why? Because we all know that balance of trade should be there between the countries. So export should not be more or else import should not be more, okay. So if we are exporting more goods means, okay, we may not we may see that some the goods, they they may not be sufficiently utilized by our country people, okay. Whenever our country is self-sufficient with those goods and services, then only the surplus should be exported to other countries only, okay. So there should be balance between, the same way in imports also, okay. So there should be balance between the imports and exports, okay. Likewise, the principal objectives here include facilitation of sustainable growth as to exports of country, distribution of quality goods and services, domestic customer at internationally competitive prices, okay. The principal objective here includes, means the foreign trade main objective includes the facilitation of sustainable growth through foreign trade, okay. Means exports and imports, it results in the distribution of quality goods and services, okay, to the domestic customer of the respective countries, okay, at internationally competitive prices. So those products, other countries products, may be availed, utilized by the domestic customer at competitive prices, okay. So we can see a sustainable growth through foreign trade development and regulations, okay. Next, coming to simulation of sustained economic growth by providing access to essential raw materials as well as enhancement of technological strength and efficiency of Indian culture, industry, services, etc., okay, to meet all kinds of requirements of the global markets, okay. means simulation of sustained economic growth, means we can see a comprehensive economic growth, okay, by providing the access to all these aspects, raw materials, okay, like technology, raw materials, all depends upon our industry, our agriculture, our services. So all comprehensively develop, okay, which leads to sustained economic growth, okay. So all kinds of requirements of the global market, according to the global market, there are many requirements regarding all these, okay, all the technology related, industry related, services related requirements are there regarding the global market. So we may reach to the requirements of the global markets, and at the same time we will have a sustainable growth in our country. Now if we see about Foreign Trade Act, okay, as we have already known that it involves 6 chapters and 20 sections, okay. So what are those 6 chapters and 20 sections define the Foreign Trade and Development and Regulation Act, okay. So if we see the first chapter, okay, so what is first chapter means? First chapter consists of preliminary sections. Preliminary is nothing but the first and foremost prime sections. So in any act, if we see, the act starts with the definitions, with the title and definitions. So that is preliminary sections, means we are having in chapter 1 short title and commencement and definitions, right? So what is short title and commencement, and at the same time what is the definition, okay. So we all know that Act, Foreign Trade Development and Regulation Act, means it provides development and regulation of foreign trade by facilitating imports into and augmenting exports, okay, from India, and for matters connected therewith or incidental thereto, okay. It means that increasing our exports, okay, to, and also at the same time development and regulation of foreign trade. And this act is enacted in the parliament in the 43rd year of the Republic of India, okay, where it contains the short title and commencement, okay. Short title and commencement is nothing but about the act, okay, about the act. So what does the act, what is the name of the act means? Foreign Trade Development and Regulation Act 1992, okay, which is enforced on the 19th day of June, okay. So the act may be called as the Foreign Trade Development and Regulation Act 1992, and at the same time the sections 11 to 14 shall come into force at once, and remaining provisions of this act shall be deemed to have come into force on the 19th day of June 1992, okay. So there are some section 11 to 14 were there, okay. So as soon as this act came into force, okay, these are also considered as the acts relating to the sections relating to 11 to 14 also considered as deemed to have into force in this act, okay, means they are continued. Previously there are we are having section 11 to 14, those will be continued in this act, okay. So short title and commencement means we are having Foreign Trade Development and Regulation Act 1992, and at the same time in the previous import and export policy we have the sections 11 to 14, those are also coming to force along with the remaining provisions in this act, okay. So now if we see the definition, so what does definition means? Definition is nothing but the different terms that we see in these act, okay, All these can be defined in this act. For example, if we see, we have Director General. So what is Director General? Likewise, import and export. So what is import and what is export? Each and everything is defined with a definition. Okay. So for example, what were the definitions that were studied under this FTDR means definitions? First is adjudicating authority. Okay. So what does adjudicating authority means? The authority specified in or under section 13. Under section 13, what is an adjudicating authority has been given. Okay, so that is considered here. So it defines adjudicating authority as the authority specified in section 13. And it also defined about appellate authority. What does appellate authority means? The authority specified under subsection 1 of section 15. According to that, appellate authority is defined. Appellate authority is nothing but the persons appealing, if at all there are any cases filed means, okay, upon the government side or else upon the trader side, if we see means those cases will be seen in this appellate authority. Okay, these Director General, they will have an appellate authority to see all those aspects. Okay, so according to section 15, this appellate authority moves on. Okay, likewise, another definition was given, conveyance. So what does conveyance means? Okay, actually conveyance means process of transporting from one place to another, or else legal process of transferring property from one owner to another owner. Okay, here conveyance means any vehicle, vessel, aircraft or any other means of transport including any animal is considered as a conveyance. These are very important. Why? Because if at all there is any contravention regarding on these terms, okay, depending upon these definitions only they can go for appellate authority. Okay, so these definitions are important. We have to know about the meaning and how the act defined those terms. Okay, now we all know about conveyance. Means conveyance is nothing but transportation which is involved in any vehicle, vessel, aircraft. Anything is treated as a transport, a conveyance. Okay, including any animal also. And another definition is given for Director General. Okay, so what does Director General means? Director General of Foreign Trade appointed under section 7. Okay, we all know that central government has authority to appoint these Director General of Ministry of Commerce and Trade. Okay, next under this, another after Director General, import and export. It defined about the import and export. We all know that importing and exporting in relation to goods bringing into or taking out of India. Okay, any goods by land, sea or air. Okay, or else in relation to services. So we are dealing export and import means exchange or transfer of goods and services. So here it is applicable for both goods and services. So the definition has given that it is related to goods and services along with technology. Okay, from territory of another country to our country or from our country to other country. Okay, likewise it has given another definition also regarding the service supplier. Okay, so who is a service supplier? Like he may from India to territory of any other country supply the services, or else in India to the service consumer of any other country. Okay, so through commercial presence in the territory of any other country, he is a supplier. Okay, likewise there is an importer exporter code number. Okay, means the code number granted under section 7. Similarly, it has defined about the license also, means a license to import or else a license to export, and includes a customs clearance permit and any other permission issued or granted under this act. Okay, license is given for what? It gives a permission to other person. Okay, issuing, granting. Okay. Likewise, order means any order made by the central government under section 3. So this is also defined there. Order means the order which has given by the central government. Okay, it should be followed by the director general. Likewise, the prescribed means prescribed rules made under this act. So for that also defined. Services also defined. Okay, means service of any description which is made available to potential users and includes all the tradable services specified under the general agreement. Okay, likewise, as I said before, service supplier means who supplies a service and who intends to take benefit under the foreign trade policy. Likewise, specified goods or technology, as I said before, some specified class of goods and services or technology is not allowed, is prohibited, is restricted for export, import, transfer, retransfer, transmit and transshipment. Okay, because of imposition of conditions on the grounds of their being pertinent or relevant to India as a nuclear weapon state, or to the national security of India, or to furtherance of its foreign policy, means it is against to foreign policy, international law, if at all the country, if at all our country is in obligation under any bilateral or multilateral or international treaties, covenants or conventions. So in such cases also, okay, there are some prohibitions and restrictions on these specified goods or services or technology. Okay, technology means any information other than in the public domain that is capable of being used in the development or production. Okay, the development, production or use of any goods or software is a technology. Okay, which helps in the development and production or use of any goods or software. Okay, so the development or carrying out of any industrial or commercial activity or the provision of service of any kind. Okay, so those can be treated as a technology, means it should be useful, development, for the development. Technology means why we are using, means for the development or else for the production process or for use of any goods or software. Okay. And so if we see chapter 2, okay, under chapter 2 what can we study, means chapter 2 is regarding the powers of central government to make, order and announce foreign trade policy. So what are the powers of central government? Means central government has the power to make provisions relating to imports and exports. Okay, initially in features only we have studied these powers. Central government is the apex body, it has the power, it has the powers to make provisions relating to imports and exports and continuance of existing orders. Okay, let us see what is that. And foreign trade policy, appointment of director general and his functions. So these are the 4 points, 4 sections. Okay, this is section 3, section 4, section 5 and section 6. Okay, and these are the chapters. So under section 3, so what powers were there for central government? Okay, so central government may by order publish in the official gazette make provision for the development and regulation of foreign trade by facilitating imports and increasing the exports. Okay, here central government make provisions for developing and regulating, okay, by facilitating exports and also and also for imports. Okay, so how it is doing means it makes provisions for prohibiting or restricting or otherwise regulating some specific class of cases, and some exceptions also it is given. Okay, for the import or export of goods or services or technology, provided that provisions of some subsections will be applicable. Okay, means we know that under this provisions were made for some imports and exports. Okay, so in that provisions to a specified class of goods and services. Okay, also they should be according to the provisions of the subsections in this act, then only restrictions will applicable. Okay, so what are those provisions provided in subsection means in case of import or export of services or technology, only when the service or good or technology provider is availing benefits under the foreign trade policy or is dealing with specified services or specified technologies. Okay, that provision will be applicable. Okay, applicable in such cases, as we know that some specified classes are not allowed, restricted. So if such in such cases, if at all any dealer or any trader is there means, okay, so uh, that class of traders are not they are punished. Okay, so powers to make provisions relating to imports and exports, in such cases central government has the powers. Okay, according to subsection in some cases to some traders, according to the provisions of those subsections, the central government has the authority, okay, to not to restrict them. Okay, so it has some powers. Likewise, under this only, under subsection 2, there are some goods which are considered as deemed to be goods which are prohibited by section 11 of the Customs Act. So this central government has the authority, central government has power to accept or applies some goods as deemed to be goods, okay, of import or export of which has been prohibited under section 11 of the Customs Act. Okay, so and all the provisions of the act shall have effect accordingly. The central government has the same power, okay, as they were prohibited in section 11 of Customs Act 1962. They have the same effect accordingly in this act also. So the powers vest with the central government to allow that. And coming to another one, without prejudice to anything contained in any other law or rule, regulation, or notification or order or license shall be necessary for import or export of any goods, nor any goods shall be prohibited for import or export except as may be required under this act, or rules or orders made thereunder. Okay, means without prejudice. Actually prejudice means biased, okay, but here unbiasedly, without any prejudice. Okay, anything in any other law, rule, regulation, permits or licenses, all shall be necessary for import or export of any goods. Okay, nor any goods shall be prohibited for import or export, only except according to the provisions of the act they will be followed, or else the rules or orders according to the act. Okay, so powers will be given to exercise on all these acts, okay, by the central government. Okay, means they will be continued according to the provisions of those acts. Okay, and if we see continuance of existing orders means it means that all orders made under the Imports and Exports Control Act, we have before previously we have Import and Exports Control Act 1947, no? So in that place we have enforced this FTDR. So all orders in that Import and Export Control Act, okay, they will come in force immediately before the commencement of this act only. Okay, so that powers are there for the central government to give continuance of existing orders. Okay, all will be continued in force immediately before the commencement of this act. But if they are not inconsistent with the provisions of this act, they will be continued to be in force, and also they are considered to be deemed to have been under this act. All applies in this. So continuance of existing orders can be seen in this. Okay, next one is FTP, foreign trade policy. Okay, so under foreign trade policy, uh, central government from time to time it formulates and announces by notification in the official gazette the foreign trade policy. Okay, and how the policy will be and how they will amend the policy. Okay, through notification in the official gazette, they will give time to time announcements, notifications. Okay, so but provided that the central government may direct that um, in respect of special economic zones. Okay, so in respect of special economic zones, that a foreign trade policy shall apply to goods and services and technology. The foreign trade policy shall apply to goods, services and technology with such exceptions, modifications and adaptations as may be specified by it by notification in the official gazette. We all know that it has special economic zones says. Okay, so those are meant for the development of the country. Okay, exclusive powers will be there for this central government. Okay, so any thing will be, any foreign trade amendments or else any formulations, any notifications will be in respect of special economic zones also. Okay, so foreign trade applies for that special economic zones also. Okay, and if we see appointment of Director General and his functions means, so appointment of Director General, the central government appoints this person, Director General of Foreign Trade, for the purpose of act. Okay, so he is known as DGFT, Director General for Foreign Trade, and this Director General advises the central government in formulation of the foreign trade policy. Okay, and also is responsible for carrying out that policy. Why? Because he is the adjudicating authority for the foreign trade policy. Okay, likewise the central government may by order by order published in the official gazette direct that any power exercisable by it, okay, by the central government under this act may also be exercised in such other cases also and subject to conditions. Okay, according to that conditions it may exercise in other cases also. The power of central government has that. Okay, and the Director General, through Director General it exercises the power, or such other officer subordinate to the Director General as may be specified in the orders. Okay, but some in some sections like section 3, section 5, section 15, section 16, section 19, in these sections, other than these sections, there is power for the central government, for the Director General to exercise their powers except these sections. Okay, so if we see chapter 3, so chapter 3 deals with importer exporter code number and also licensing aspects. Okay, so any importer or exporter needs a code number to import the goods or export the goods, and at the same time there should be a license. So license is granted again by the Director General of the adjudicating authority, who is appointed by the central government. Okay, so in this also, while issuing the license also, uh, if in suspension, cancellation, importer exporter code number can be done. Okay, so it is also done by the Director General only, because it is the only adjudicating authority to deal with all these aspects. Similarly, the issues, suspensions and cancellation of those licenses. Okay, regarding these, they can go for appeal. Okay, so appeal is nothing but if at all there is any punishment given to the traders. Okay, so on those issues they can go for appeal. Okay, or else if the Director General, they feel that if there is any contravention, they can go for appeal. So these aspects can be studied under the under the chapter 3, where importer exporter code number and license. So regarding these code number and license issues, this chapter will deal. So under this, section 7, section 8 and section 9 will be studied under these aspects. Okay, so if we see importer exporter code number. Okay, so code number means no person shall make any import or export except under an importer exporter code number. Okay, so that is, the code number is granted by the Director General. Okay, Director General gives the code number, or who is the officer authorized by the Director General. Okay, a Director General will appoint the authorized officer also. Okay, so on his behalf, this authorized officer may also issue the code number in accordance with the procedure specified by the Director General. Okay, but provided in that in case of import or export services or technology, the importer exporter code number shall be necessary only. Okay, importer exporter code number is necessary when the service or technology provider is, goods or services or technology provider is taking benefits, okay, under the foreign trade policy, or is dealing with specified services or specified technologies. Okay, then to those persons, code number should be compulsory. Okay, code number should be provided. Importer exporter code number is necessary. Okay, either it may be goods, service or technology. If we see suspension and cancellation of importer exporter code number, in which cases, okay, this suspension or cancellation of code number will be done. Okay, means any person who has contravened any of the provisions of the act, any of the provisions of the rules, orders, okay, made by the foreign trade policy or any other law for time being in force relating to the central existence, or else relating to the customs, relating to the foreign exchange, okay, has committed, not only contravened, contravention means nothing but offense. Okay, a person who has done the prohibited act, okay, so who offended the law, who conflicts with the law, so it is known as the person who has contravened the provisions. So not only contravening the provisions, okay, breach of law, but also any other economic offense also considered, any other economic also done by that particular trader, means under any law for the time being in force as specified by the central government through notification of official gazette. Okay, in such cases, okay, suspension or cancellation of importer code number, importer or exporter code number will be done. Okay, right, in which case, in contravention case. Okay, likewise prejudicial to the trade relations of India. Okay, prejudicial okay, prejudicial to the trade relations of India, or else disrepute our country regarding the goods, services, technology. So in such cases also, importer or exporter code number will be suspended or else cancelled. Okay, means here prejudicial means biased. Okay, if at all that particular importer or exporter is a biased person, okay, he used the trade relations for his own benefit, okay, which affects the country interest of other persons engaged in imports or exports, okay, or else it disrepute the credit of our goods or services or technology provided from the country, okay. In such cases also, exporter importer code number, okay, and license all will be suspension, undergoes suspension or cancellation, okay. Likewise, issue, suspension and cancellation of license, okay. So sorry, here importer exporter code number, no. So under this, contravention to provision of this act also leads to the uh, cancellation of the importer exporter code number, okay, or suspension of the code number. So contravention to provision of this act means, according to the Foreign Trade Development and Regulation Act, if that particular importer or exporter have not been acted means, so it undergoes, it can be considered as contravention, okay. Contravention to provision of that act means he is offending against the prohibition of the act, he is conflicting with the act. So contravention leads to suspension and cancellation of importer or exporter code number. First thing also relating to contravention only, contravention, prejudicial, again contravention. So this contravention is related to the rules, orders of any law, okay, because we are dealing with many laws of foreign exchange. Therefore, so any loss of exchange regarding to economic offenses also all comes under this contravention. But this contravention is related to this FTP, this Foreign Trade Development and Regulation. So if at all under this act any provisions were not fulfilled, or else if he is not according to he is not acting according to these provisions means, it is considered as a contravention. So therefore, under importer exporter code number, this contravention of other laws or economic offenses, prejudicial acts, or else contravention of the provisions of this FTDR Act, okay, can be lead to suspension and cancellation of importer exporter code number, okay. So after that, issue, suspension and cancellation of license, okay. Before going to this act, okay, this section 9, under this only, as I said that Director General will suspend, cancel the code number of importer or exporter, no. So before that, the Director General or any other officer authorized by him may call for the record, okay, or any other information from that particular person, okay. After giving to that person a notice in writing, a notice will be given in writing informing that in which grounds or else on which grounds it is proposed to suspend or cancel that importer exporter code number, okay. And after giving him a reasonable opportunity of making a representation in writing within such reasonable time as it will be specified in the notice, that within a period of time you have to respond, okay. So in that notice they will mention, so if that person so desires of being heard, suspend for a period as may be specified in the order, or cancel the importer exporter code number granted to that person, he has the importer or exporter, okay. That person may respond after receiving the notice also, that particular importer or exporter, okay. And also here that he, after cancellation this, he is not entitled to export or import the goods and services or technology except under specialized license only. Okay, so if at all a person code number okay is cancelled, okay, so that person is now not entitled to do exports or imports. Okay, but he can, when means except under specialized license which is given again by the Director General. Okay, then only he is allowed. And if we see third aspect, that which is nothing but section 9, issue, suspension and cancellation of a license, means the central government levy fees to such exceptions. Okay, so as I said here, some except specialized licenses will be given by the this general. Okay, so Director General. So in such cases, okay, how the Director General will give specialized licenses, means central government levy fees to such exceptions. Okay, central government levy fees on those persons for those exceptions. Okay, and they will grant the license. Okay, or else the renew the license as may be prescribed according to the case may be. Okay, and also here this central government has given some option for that person to apply. Okay, so for those exceptional persons to for granting or for renewing. Okay, and in another aspect after that, receiving applications by Director General. So those applications will be received by whom, means Director General will receive those applications. Okay, so after making a proper inquiry on that particular importer or exporter, he will grant or he will renew, or else he may refuse, okay, that application. If renewed means, okay, then renewal may be done according to the provisions of the act. Okay, and Director General. So again whenever this cancellation or suspension of this license is going to be done, no such suspension or cancellation shall be made except after giving the holder of the license or certificate or any instrument bestowing financial or fiscal benefits to of that particular trader a reasonable opportunity of being heard. Okay, reasonable opportunity of being heard, OBH, opportunity of being heard means it is given to the trader by the Director General. Okay, why? Because on which grounds cancellation or a suspension has been done, for that he will give his reasonable aspects. Okay, so an appeal against an order order refusing to grant or renew or suspending or cancelling a certificate or license shall lie in like manner as an appeal against an order would lie under section 15. Okay, so according to the provisions of the act, according to section 15, if at all they have gone for appeal for refusing to grant or renewal, so they will act according to the provisions of the section 15. The Director General will act according to the section 15, according to the provisions of the act. So they will decide to issue or refuse to grant or renew, or else suspend or cancel. So anything may happen depending upon the Traders Act. Okay, and also depending upon the provisions of the act. So finally the trader will go for appeal for refusal of that grant or um, renewal, or else for suspending or cancelling of the license, and the Director General will act according to the section 15 of the provisions of the Act, Foreign Trade Development and Regulation Act. Okay, so if we see chapter 3, under chapter 3 it is related to quantitative restrictions. Okay, so under quantitative restrictions we will deal with section 9A. Okay, so what does quantitative restrictions means? See here, quantity means we all know the numerical value. Quantity means, so how much quantity should be imported to our country, or else how much quantity should be exported to the other country. So there will be restrictions on those quantity of imports or exports. So who has the power means central government will impose those quantitative restrictions. Okay, so why these restrictions will be done means, so for example, as I said before, without fulfilling the needs of our country people, okay, we should not sell our goods and services to other country. Okay, why? Because it increases the cost of that particular good because of scarcity of that particular good. Okay, so likewise prices also will be increased due to that scarcity of goods and services. Therefore, first of all, the country people should be fulfilled. There should not be scarcity in our home country, then only exporting will be allowed. So therefore quantity restrictions will be made for imports and exports by the central government. Okay, so if we see first one, 9A, power of central government to impose quantitative restrictions. So who will have the power means the central government will have the power to impose quantitative restrictions. Okay, so under this, if importing goods cause serious injury to domestic industry, means the industry people of our country, if it importing the goods of other country, if it seriously affects our country's people, industry people, domestic country people means, okay, by notification it imposes, central government imposes such quantitative restrictions. Okay, but provided no restrictions shall be imposed on any goods, okay, originating from developing countries. So developing countries will be exempted. Okay, so if at all that particular good is importing from a developing country, originating from a developing country, means on such countries there will be no restrictions imposed unless revoked or else cease to have effect on expiry of 4 years from date of imposing time. Okay, if at all we have already imported those goods means, okay, so the government has authority to seize those goods. Okay, and also till 4 years of the expiry from the date of imposing the imposing the act on them. Okay, after completion of 4 years they will not be allowed. Okay, so after that they will be allowed after 4 years of expiry of seizing. Okay, so here the central government by rules provide the manner in which goods the import of which shall be subject to quantitative restrictions under this act may be identified, and the manner in which the causes of serious injury, causes threat in relation to such goods will be determined in the act. Okay, so those are framed by the central government. So which products should, which goods and services are restricted, quantity restrictions are on which goods. So for this purpose, as I said before, it defined developing country and domestic country. Developing country means for which country notified by the central government in the official gazette. So to those countries only this is applicable. Okay, exemption is applicable. Likewise, domestic industry is also defined in this act. Domestic industry means, as I said before, it should not cause any threat to the domestic industry manufacturers. So what does domestic industry means? The producers of goods, okay, including producers of agricultural goods also comes under this domestic industry section, okay. So finally, if it affects serious injury, threat of serious injury directly to the competitive goods in India, so in such cases it is not allowed. So quantity restrictions will be made on those aspects. If we see, next one is chapter 4, okay. Chapter 4 is related to search, seizure, penalty and confiscation, okay. So here the central government has given power to the Director General or adjudicating authority to search, to seize, to levy penalty and also confiscation, okay, to the Director General of FTDR, okay. So what is related to search or seizure, penalty, confiscation means the adjudicating authority has the power to search if at all there is any misconception on the trader's side. Means adjudicating authority has every right to search in their documents, records, everything, okay, entering their premises where the goods and services are kept, stored or processed, manufactured, traded or supplied or received, okay, for the purpose of import or export in such in those places, okay. Searching, inspecting and seizing of such goods or services or technology, documents, things and conveyances connected with such imports and export of goods can be searched by the adjudicating authority, okay. So that is powers relating to search and seizure. Seizing means if at all in search those goods and services are not according to the provisions of the act, means they will be seized by the authority, okay. Provided that this clause will be applicable in case of import or export of services or technology only when the service or technology provider is availing benefit for the foreign trade policy or is dealing with specified services or specified technologies. In such cases, this power is availed by the Director General or adjudicating authority, okay. So if we see contravention of provisions of this act means, okay, so what does contravention of this provisions of this act means? No export or import shall be made by any person except in accordance with the provisions of the Act, the rules, orders made there under FTP or else foreign trade policy for the time being, okay. So no person or export or import can be made by any person. Only they can act according to the provisions of the Act only. So contravention of provision means if they act against to the provisions of the Act, means it is considered as contravention. Contravention is breach of law. They are not acting according to the law, okay. So where any person makes or attempts to make any export or import in contravention of any provision of Act means he shall be liable to a penalty of not less than 10,000 rupees, okay. Contravention leads to 10,000 rupees, not less than 10,000 rupees. Penalty will be there. Why penalty? Means they are contravening the provision of the Act, which is nothing but they are not acting according to the provisions of the Act, okay. And also not only 10,000, okay, but also more than 5 times the value of the goods, more than 5 times the value of the goods. For example, the value of the goods is 1 lakh. So 1 lakh into 5 means 5 lakhs. So they have to pay 5 lakhs penalty for the contravention of provision of the Act, okay. Likewise, it is the same applicable to for the services and technology also. And where any person sign or uses, okay, or cause to be made, signed or used any declaration, statement or document submitted to the Director General or else any other officer authorized by him, if the declaration is, we all know that a declaration will be given by the trader that so and so material is being exported or imported, so and so amount, so and so value of worth, okay, by a declaration form which is attested by him, okay. So if such attestations are not made by him, or else if at all there is any forgery have done, tampered, okay, and if any false in material was there, he shall be liable to a penalty of not less than 10,000 rupees or more than 5 times the value of the goods, as I said here, okay. So in case of contravention, or else in case of forgery doing, okay, forgery signing, in such case also penalty will be there, like not less than 10,000 and also more than the value of the 5 times of the goods or services, okay. And where any person on a notice to him by adjudicating authority admits any contravention in specific classes which are prescribed by the provision of the act, so that amount also should be paid by that person, okay. If at all any notice is given by the adjudicating authority regarding that contraventions, okay, so the amount should be paid by that trader. Why? Because adjudicating authority has given him a notice, okay. According to that notice, the prescribed or determined amount should be paid by that particular person, and a penalty also imposed under this act, okay. If at all that penalty is not paid by the person, means it will be recovered by from his material, from his goods and services, okay. So even though penalty is imposed on that person, if at all that person is not being paid, so the amount will be deducted from their worth of goods which are going to be traded, okay. Or else the Director General deduct or require any officer subordinate to him to deduct the amount payable under this act from any money owing to such person. Why? Because these importers and exporters, they will involve in the trade, okay. They may get money from the authorities regarding those transactions, means so that money owing to such person will not be payable to that person, okay. That particular entitled authority officer will hold on that amount, okay, and that payment will be made here under this penalty. Or else the Director General may require any officer of customs to deduct the amount payable under this act. If at all from customs office any amount has to be given to that particular penalty person, means so that amount will not be given to that person, okay. So it will be given to that Director General, okay, amount payable to that act according to that act. And Director General may require the Assistant Commissioner of Customs or Deputy Commissioner of Customs or any other officer of customs to recover the amount so payable by detaining or selling of those goods, okay. Why all these things are going done, means if at all the person is not ready to pay the penalty amount, means in such cases all these aspects will be done, okay. Finally the worth of their goods will also be detained or sold, okay, sold that person's goods, okay. If the amount still not cannot be recovered from such person also, okay, the Director General or any officer authorized by him may prepare a certificate, okay, signed by him, specifying the amount due from such person and send it to the collector of the district in which such person owes any property or resides or carries on business, and said collector on receipt of such certificate shall proceed to recover from such person, the amount specified there under. Okay, so not only if at all that penalty is not paid by the person, if all these aspects have not been done, if like a customs authority and other according to other acts also, if at all that person is not owned any amount means, then in such cases how to get collect money from that particular person means, Director General prepare a certificate signed by him specifying amount of such person, sending it to the collector of the district. Okay, and he will see the person's own property or where he is residing, where he is carrying on his business, and shall collect the amount specified thereunder from there. Okay, or the Director General or any officer authorized by him accordance with the rules made in detain any movable or immovable property belonging to or under the control of such person, and detain the same until the amount payable is paid. Okay, the Director General or else the officer authorized will go to that person, okay, exercise their power that that particular person's movable or immovable property will be detained by the authorities till the amount is paid by that person. Okay, and if at all even though he has not been paying means, okay, then the said property will be sold. Okay, with the proceeds of such sale they may satisfy the amount payable and costs including cost of sale remaining unpaid, and shall render the surplus if any to such person. Means they will sell the property, they will take the amount that is specified or determined in that certificate. Okay, and if at all there is any surplus by selling that particular property, it will be given return to that particular person. Okay, or else if at all there are any bonds or instruments executed under the act means, okay, those bonds or else those instruments will be recovered from that person. Okay, without any prejudice they will recover and they will collect the amount. Okay, so importer or exporter code, any person who fails to pay any penalty imposed under this act, he may be suspended by adjudicating authority till the penalty is paid or recovered. Okay, so till the penalty is paid or recovered, he will not be given his code number, it will be cancelled. So wherever any contravention of any provision of the act or rules or orders made under this FTP, foreign trade policy, together with any package covering or any conveyance shall, subject to such conditions and requirements may be prescribed, will be liable to confiscation by the adjudicating authority. So contravention of any provision of the act, okay, will be liable to confiscation by the adjudicating authority. And if we see here, so ipudu crediting sums realized by way of penalties. So we have collected the amount from the person, penalty is collected. So where it is credited means, it is credited in the Consolidated Fund of India. Okay, then afterwards, empowering settlement commission for regulation of export obligation default. Okay, means settlement of customs duty and interest thereon as ordered by the Settlement Commission as constituted under Section 32 of Central Excise Act shall be deemed to be a settlement under this act. How the worth is settled means, okay, according to the Settlement Commission, okay, according to that only the settlement of customs duty will be done. Okay, according to the Section 32 of Central Excise Act. Okay, so that is known as Empowering Settlement Commission for regularization of export obligation default. So default has happened. How to regularize that default? Means it depends upon the, according to section 32 of Central Excise Act. Okay, so settlement of customs duty can be done depending upon that Central Excise Act. And also penalty or confiscation not to interfere with other punishment. So no penalty will be imposed or confiscated. Okay, may according to this act. Means this act will prevent the imposition of any other punishment to which the person affected thereby is liable under any other law for the time being in force. Okay, till this is completed, no person is going to be punished under any other law other than this. Okay, next, adjudicating authority. Any penalty may be imposed or any confiscation may be adjudged under this act by Director General. He is the only person who can impose the penalty or any confiscation, subject to such limits as may be specified by the officer, as the central government may by notification in official gazette authorizes on this behalf. Okay, so adjudicating authority will impose the penalty depending upon the central government notification in the official gazette. Next one is giving an opportunity to the owner of the goods. So why opportunity should be given to the owner of the goods means, so after imposing a penalty or adjudicating any confiscation on that particular person, owner of the goods means, regarding the conveyance or any other act, okay, a notice will be given to him by the Director General from the adjudicating authority in writing form. What means? Informing that particular owner that on which it is proposed to impose a penalty or to confiscate the goods or conveyance. Okay, they will write the reason on which grounds they have imposed penalty. Means they are telling through a notice to him why they are imposing penalty. Okay, likewise, to make a representation in writing within such reasonable time as may be specified in the notice against the imposition of penalty or confiscation mentioned therein, if he so desires of being heard in that matter. Okay, means after receiving the notice, okay, that particular owner, he may, if he want to say the reason for that act, means, okay, he can go for heard, being heard in the matter, means through appeal he can approach the Director General. Okay, next, another one is chapter 4a. So what does chapter 4a means? Control on export or specified goods, services and technology. Control on goods. First one is section 14a. So section 14a controls on export of specified goods, services and technology. As I said before, certain goods, certain specific goods and services and technology are referred in the chapter of this act. Okay, so like weapons of mass destruction or delivering the systems of that particular weapons or mass destruction, or else prohibition of unlawful activities will be there. So those activities, or else exports, transfers, retransfers, transshipment, brokering in specified technology are not allowed. Okay, so control on export of specific goods, as I said before. Okay, so those are not allowed according to this chapter 4a. Means it is controlling on export of specified goods and services and technology. Okay, likewise, all terms, expressions or provisions of the weapons of mass destruction and their delivery systems shall apply to the specified goods and services only. Okay, as the central government, it gives certain prescription and it determines certain aspects. Okay, certain goods and services and technology, to those only it will be applicable. Okay, the central government may by notification. How it will determine means through notification in the official gazette, it directs that certain shall not apply to goods and services or technology. or certain, it shall not apply to any goods and services or technology with some exceptions, modifications and adaptations as may be specified in the notification. Okay, means specified goods will not be allowed. Okay, but in gives some provisions. Okay, by giving notification in the official gazette, in that official gazette, it will specify the goods and services which have given provision, and also which are exempted by some exceptions, by some modifications, by some adaptations. They may be accepted by the central government. Okay, so all this can be done through only the gazette, official gazette, by through notification. And if we see for section 14b, what does it states means? Transfer of control. Okay, transfer controls means central government by notification in official gazette, it makes the rules. Okay, it gives the provisions. So in connection with these all these things, the imposition of control in relation to transfer of specified goods and services, okay, all these can be given in the notification of the official gazette. Okay, the regarding the transfer controls. Okay, so no goods or services or technology notified under this chapter shall be exported or shall be transferred, okay, or retransferred or brought in transit or transshipped except in accordance with the provisions of the act only. Okay, the weapons of mass destruction, delivery systems, prohibition of unlawful activities or any other relevant act. Okay, regarding all these things, no goods or services or technology are not allowed unless until it is notified under the chapter. Okay, by notification in the official gazette. So transfer or shipment can be made only through official gazette. If they give any provision according to that only, they are allowed. And if we see 14c section, catch all controls, means here no person is allowed, okay, to export any material. That is known as catch all controls, means any material, any equipment, any technology, knowing that such material, equipment or technology is intended to be used in the design or manufacture of a biological weapon, chemical weapon, nuclear weapons. So these are all not allowed by the government. So therefore, if at all that particular person is going to export those materials, okay, those are not allowed, and it comes under the section 14c of catch all controls. Okay, all controls regarding the explosives. Okay, and if we see 14d, section 14d, suspension or cancellation of a license, means the Director General or officer authorized by him may by order or suspend or cancel a license to import or export of specified goods or services or technology without giving the holder of the license a reasonable opportunity of being heard. Okay, but such person shall be given a reasonable opportunity of being heard within 6 months of such order, and thereupon Director General, if necessary, by order in writing, confirm, modify or revoke such order. Okay, according to 14d, suspension or cancellation of a license can be done by the Director General. Okay, without holding, okay, without giving the holder of the license any reasonable opportunity to heard. We all know that opportunity to heard will be given to the trader by the Director General. He can give his reason of his contravene action. Okay, so here in this of section 14d, okay, this reasonable the Director General, without giving the holder of license a reasonable opportunity of being heard, will be done. Okay, but such person shall be given a reasonable opportunity of being heard within 6 months, okay, of such order, and thereupon the Director General, he will give an authorization, okay, to that particular trader by hearing the reasons, and confirm his license by order in writing, okay, that he is modifying or revoking the order. He may give the order or he may revoke that order. Who? Director General, in case of this suspension or cancellation of a license, okay. So if we see 14A, offenses and penalties. So offenses and penalties, doing a wrong thing, and penalties will be imposed on those wrong things, okay. So in case of a contravention offense relating to specific goods, as I said before, there are certain specified goods and services or technologies, okay, that are not allowed for export and import of goods, okay. So penalty shall be in accordance with the provisions of the weapons of mass destruction and their delivery systems. Why? Because these are specifically prescribed, determined in the law, in the act. So therefore, if they contravene in these related acts, means, okay, it is considered as an offense and penalties will be imposed. Where any person contravenes or attempts to, not only contravenes, if at all he attempts also to contravene any of the provisions of this act, means regarding these specified goods and services, without prejudice to any penalty which may be imposed on him, be punishable with imprisonment for a term stipulated in the weapons of mass destruction and their delivery systems, or else prohibition of unlawful activities, okay. Means not only financial penalty will be imposed, but also imprisonment will be there, okay. So no court shall take cognizance of any offence punishable under this chapter without the previous sanction of central government or any officer authorized on this behalf by central government by general or special order, okay. So after taking authority, or else after giving penalties, after having a certain judgment regarding that offence, okay, no court will take any cognizance of any offence, okay, without the previous sanctions of the central government. If we see chapter 5, okay, so chapter 5 means appeal and review, okay. So appeal means any person aggrieved by any decision or order made by the adjudicating authority under this act may prefer an appeal. So appeal means he is not satisfied with the judgment given by the Director General. Then that particular importer or exporter will go for the appeal. So to listen his side of points, okay. So where the decision or order has been made by the Director General to the central government, the decision or order has been made by an officer, okay, authorized by the Director General to hear the appeal. So who will hear this appeal? Means Director General or any other officer subordinate to the Director General will hear this appeal, okay. So within a period of 45 days, within a period of 45 days, okay, from the date on which the decision or order is served on such person. So within that period, okay, he has to approach. So provided that the appellate authority may, if it is satisfied with the appellant was prevented by sufficient cause from preferring. So after appeal, if we see about review, so review will be made by the adjudicating authority regarding the legal aspects of the case, okay. So they will see that they will review the records of the person, okay, the reason, they will examine the records of any proceedings, okay. So according to the correctness of the person, the legality of the person, decisions or orders will be given, okay. So a reasonable opportunity will be given to that particular person to make a representation, okay. So for hearing his case, okay, being heard in his defense. So this is a review. So after appealing, they will go for a review to see his case. So after that, powers of adjudicating and other authorities means every authority making any adjudication or hearing any appeal. Okay, so this person is going for appeal, no? So in that case, every authority making any adjudication regarding that hearing case, regarding that appeal, exercises power under this act according to the powers of civil court. Okay, how the civil court takes decisions regarding that civil code under the code of civil procedure. Okay, they will try to solve the suit. Okay, so they has the powers of adjudicating authority means they will have summoning and enforcing the attendance of witness. They have the power to require the discovery and production of any document, or they will requisitioning any public record or copy thereof. Okay, they will see any evidence is there, or else they will see issuing commission for examination of witness. So all can be seen. Okay, every authority who making adjudication, so any appeal or exercising any powers under this act shall be deemed according to the civil code for the purpose of these code of criminal procedures. Okay, likewise every authority making any adjudication, hearing appeal, exercising any powers under this act, okay, shall have the power to make such orders on an interim nature as it may think, if it may also sufficient for the case, and order the stay of operation of any decision or order. Means in this case, if at all it is necessary, interim orders can be given by the adjudicating authority. It has that powers. If at all it is sufficient cause is there to give a stay on that operation. Okay, so that authority is given for this adjudication. And clerical, or if at all there are any arithmetical mistakes regarding that person, okay, in any decision or order or errors arising therein, from any accidental slip or from any omissions may have been made in the records, means those are corrected by the authority by which the decision or order was made, either on its own motion or on application of any other parties. So therefore, if there is every right for the adjudicating authority to clear on all these aspects regarding the clerical or arithmetical mistakes in any decision. Okay. But according to the subsections, they have to act. Okay, it should not affect any person. So all these powers will be given to these authority, adjudicating authority, provided that it should not affect any person. Okay, so according to the subsection only, provisions only, it has to act. Finally, if we see chapter 6, it is related to the miscellaneous. So miscellaneous means protection of action taken in good faith, application of other laws, power to make rules, repeal and savings. In these cases, these are considered as miscellaneous sections. Okay. So protection of action taken in good faith means no order made or deemed to have been made under this act shall be called in question in any court. No suit, prosecution or other legal proceedings shall lie against any person, anything in good faith done. Okay, so in that case they are not considered. Okay, they are intended to be done under this act, or any order made deemed to have been made there under. Okay. Means regarding the protection of action taken in good faith, in such case, okay, that person will not be questioned in any court of law. And if we see application of other laws not barred, means the provision of the act shall be in addition to, not in derogation of, the provision of any other law for the time being in force. Means if at all this person is in one case, so other, if at all he is in other cases also, so there is provision of act that other laws are not barred here. Okay, so another one is power to make rules. Means central government may by notification in the official gazette make rules for carrying out the provision of this act. So we all know that central government has the ultimate powers. Okay, so through notification in the official gazette, it will makes the rules. Okay, so like it has exceptional powers, like for example, the manner in which the conditions subject to which a special license may be issued, okay, under subsection 2. Likewise, if there is any exception subject or else exception class, exception person, in such case also it may be granted or renewed, okay, by the central government. So it has that power. Likewise, in special class of goods also, in special class of service or technology also, okay, it may grant. Likewise, the form in which the terms, conditions, restrictions were there to some cases, no, so for that also it may grant under subsection 3 of section 9. Means it has external powers, it has exceptional powers to exercise its powers on these aspects also, but according to the provision of these subsections. Okay, likewise, in case of suspension or cancellation also, okay, in that case also conditions to subject to some cases, it has powers. Central government has the powers to make rules regarding those aspects. Likewise, in importing of goods, like quantitative restrictions were there, no, so in such cases also, according to subsections determined, it can make the rules regarding those aspects also. Likewise, means amendments are making rules were making by the central government regarding all these aspects. Actually, these aspects were not were regulated or restricted, but in certain conditions the rules may be framed by the central government. So these are known as the power to make rules. But coming to repeal and savings, so the imports and exports control act is there, no, and foreign trade development and regulation ordinance 1992 are hereby repealed. Okay, so repealed is nothing but in imports and export control act, in the it is replaced by the foreign trade development and regulation act. So the repeal of imports and exports, it will not affect, okay, that control act, it will not affect the previous operation of the act. Okay, so repealed or anything duly done or suffered there under, means previous operation act, if at all they have been taken any action, means operation, means, so it will not be any there will not be any effect, or it will not, that operation will not affect by repealing this act. Okay, likewise, any right, privilege, obligation, liability acquired or else accrued, okay, the act so repealed are also, it also does not affect. Likewise, penalties, confiscations, punishments, contraventions under act are so repealed are also will not affect. Why? Because previous operations already done, so they will not be affected, get affected. Okay, so so notwithstanding the repeal of the foreign trade ordinance, anything done or any action taken under the said ordinance shall be deemed to have been done or taken under the corresponding provisions of this act. Okay, so these are the 20 sections regarding the FTDR, okay, Foreign Trade Development and Regulation Act. So till from definitions to repeal and savings, okay, all the sections are, all the rules, all the notifications, all the regulations, restrictions are regarding to the foreign trade. Okay, so this is about the FTDR.